Hello and welcome to Columbia, or to this building. I think it's actually, I work in a law school library. I'm Kent McKeever, I run the library. And this is, to be honest, the first time I've been in this building. It can be very isolated, different places on campus. This is the last of the sessions this year on scholarly communication. And we have three people speaking on the issues of copyright and scholarship and how the business works now and perhaps will work in the near future. I'm agog about this because I come from the law library world, which has the law publishing and academic publishing and law is its own weird little economic system that bears virtually no relationship to anybody else's. So this is all new to me. Our speakers today will be, first of all, Kenny Cruz. Many of you have probably already met him. He's the director of the Copyright Advisory Office here at Columbia. For more than 20 years, his research has focused on copyright issues, particularly as they related to the needs of scholarship and the university. Before coming to Columbia, he was a professor of law and of library and information science at Indiana University. Dr. Cruz is the author of several books and articles on copyright law, teaches copyright law at the Columbia Law School and in an advanced degree program at Munich. Our second speaker is Michael Carroll, a founding member of the board of directors of Creative Commons, a global nonprofit organization dedicated to providing legal and technical tools to facilitate information sharing by authors, educators, scientists, and all other creative individuals. Professor Carroll is also an active advocate for open access on the internet and to the scientific and scholarly literature. Professor Carroll was himself a spike on the blogosphere earlier this week when it was announced that he was accepting a full-time position at American University, Washington College of Law, which is where this one graduated from. So Lord only knows how well their alumni mafia work. Professor Carroll's research and teaching specialties are intellectual property law and cyber law. Until this year, he was a member of the faculty at Villanova, and before that, he practiced at Wilmer Cutler and served as a law clerk to Judge Judith Rogers of the Court of Appeals of the D.C. Circuit and Joyce Hens Green of the District Court of the District of Columbia. The third speaker will be Heather Joseph, who's been executive director of the Scholarly Publishing and Academic Resources Coalition, commonly known as SPARC, since 2005. It supports expanding access to the results of scholarly research through enabling open access publishing and archiving and advocating for open access policies. Ms. Joseph is also a spokesperson for the Alliance for Taxpayer Access. Coalition's been a leading voice on U.S. open access legislation, particularly for materials that we as citizens have already paid for through our taxpayer-based grants. She has spent 15 years in the scientific journal industry, both in commercial and not-for-profit organizations, and serves on the board of directors of numerous not-for-profit organizations. She is a frequent speaker and writer on scholarly communication and on open access in particular. They will speak in that order. Kenny will start, then Professor Carroll and Ms. Joseph. When we get to the question and answer period after the talks, we do have someone with a boom mic who will come around and stick the mic in your face when you ask a question, because this will also be going out as a podcast, and we want to get everybody's questions and the answers out as clearly as possible. So Kenny, you want to take off?
Sure. Thank you. Thank you, Kent, and let me bring this alive and projector on, and there we are. There we are, wonderful, thank you. Thank you all very much. I know it's a lovely spring day outside, isn't it? Wherever you might be. So it's good to see you here, and there are too many people to thank, but be sure to look around the room and thank the people who made this event possible. So getting down to business. Our question is, who really owns your scholarly work? And the first question that we really should be asking is, who cares? And there are many answers to the question of who cares. If you're the one who it's really your scholarly work, you're the one who's producing this work, the first answer is you care. And you care for a variety of reasons. because how your work is owned and controlled under whatever mechanism is going to make all the difference about the advancement of your work and the future of your own scholarship. And we'll be showing how some of this comes true a little bit later in the presentation. Publishers care, because the question of ownership or control goes straight to the economic model of publishing, whatever that economic model might be, traditional or innovative. It also goes to the question of the growth and survival of publishers, especially publishers in a traditional sense, who are now facing some formidable challenges with respect to the ability to keep the system of publishing as we know it, keep it afloat. Libraries care. Libraries care because they're facing questions of escalating cost. They're facing conflicts with the mission of information access. And readers, users, researchers, they care because they too are finding that exactly at the time where there's increased access to information, we're encountering new and sometimes burdensome barriers to the retrieval and use of that information. This is a long list to be able to address, but it's a list that I think we can begin to formulate by going back and rethinking that question of who owns your scholarly work. And so why now is really the next important question. Why in the world are we bothering with this question now when we know that our environment of scholarship has been in existence for well over a century as in a formula that's very similar to what we know it today, and indeed we can clock it back a few centuries. So why now? It's because we're seeing some change in this ecology of information creation and information use. We're seeing new technologies that are creating new opportunities for dissemination of works, for control of works, and confusion about the use and opportunities and abilities to use scholarly works. We're seeing new and diverse formats and new media come into existence as the vehicle of communication of scholarship. This digital diversity of all different types and what we might call multi-directional scholarly communication, blogs, wikis, other forms of communication, where it isn't just one direction. It isn't just from me to my audience, but it's a group, it's a consortium, it's a pooling of ideas and thinking and creativity to formulate what we know today as scholarly communication. Why now too? We also have new players, or we could say changing players coming to the table. We have familiar players taking on new roles. We have libraries functioning more and more as publishers. We have readers becoming authors. We have the public as an investor in the creation of research in the first place, the public as a responsive author, the public as a reviewer. We've talked a lot, or at least I have in the last couple of minutes, about the nature of the creation and publication of scholarship, but a critical element that we may not say a whole lot about today is peer review. And peer review is shifting as well, and the public is stepping in many cases as the reviewer, as the critique, as providing that feedback in this multi-directional realm of scholarly communication. And another new player, of course, is Google, and Google doing more things. Google as publisher, Google as creator, Google as connector, Google as disseminator. And if it isn't Google, it's somebody else. And so we're seeing these new players and changing players. And then we're also seeing changing law. Back to the theme of copyright, which we'll get to in just a moment, we're seeing that there's change in copyright law, and a lot of that change, especially through the last 10 or so years, has been in the direction of ramping up copyright protection. Stronger protection for a longer period of years, more different types of protection. And so the question of who owns and who then possesses the copyright becomes an even more powerful, more influential, more controlling kind of conclusion. And so I'll be talking a lot in the next few minutes about the importance of contracts. But let's put those contracts into the context of the legal framework of copyright. Here are just a few things that you need to know about copyright to make sense of the rest of the subject. First, copyright law protects nearly everything. Well, what do I mean by that? It protects nearly everything that you can see, read, watch, or hear. It protects works that have these two qualities. They are original works of authorship that are fixed in a tangible medium of expression. I wrote it on paper. It's my original authorship, now fixed on paper. Or it's something that's stored to the hard drive or on a web server or captured in the camera. All of these are different ways of taking original content and fixing it. And what do we get when we pass those tests? We get instant, automatic copyright protection. No requirement to do anything, no requirement to put formalities, a C in a circle, no requirement to know that you have copyright. In fact, if you don't even want the copyright, you get it anyway. So it's instant automatic copyright that's imposed on all of those diverse works. And it's a protection that lasts for a long, long, long period of years. The basic term, the law is more complicated than this, but our basic term of copyright is life of the author plus 70 more years. So pause again and think about that question of ownership of the copyright, ownership of the scholarship. We're talking about rights, legal rights, broadening legal rights that somebody now will possess for many, many, many decades to come. So there's our foundation. Now let's go to the issue of ownership in particular and examine it in this context. Who owns the copyright? If we ask that question, we kind of get an answer. And we're going to get a reasonably clear answer in most cases. But let's struggle a little bit. We have our basic rule that if we default to the law, who owns the copyright in that journal article and that website and that recording on the camera? It's the author. It's whoever did the original work is the copyright owner. There's our starting point. And if you have multiple parties, multiple contributors, a discussion among all of us, then we start to have joint copyright ownership. And we can have multiple authors sharing in the copyright. I hope you're starting to see the possibilities of confusion. We'll come back to that too. Now, sometimes I call the second half of the slide up here exceptions to that rule. That's not really quite right. Let's think about them as alternatives. So basic rule, I'm the one who wrote the paragraphs, I'm the one who owns the copyright. Well, here's some alternatives to how that could come out. First is the concept of work made for hire. If I created that work, particularly in the context of being an employee, acting within the scope of my employment, my duties at the university, for example, then that could qualify as a work made for hire, in which case my employer owns the copyright to that particular work. So I'm the one who actually wrote it, but now somebody else owns it. Next on the list is transfers. Very important for our topic today. That we might conclude I own the copyright or you own the copyright, but we might not want that result for whatever reason. The law allows us to shift that copyright and move it to somebody else. But that we need to take care of through an agreement. And then very important on the list is divisibility. The notion that the copyright is not one cohesive whole. It could be treated in that manner, but it doesn't have to be. And so the law gives us an opportunity to be able to take the thing called the copyright and unbundle it, to break it up into its pieces. And maybe I only want some pieces, and you want other pieces, and somebody else wants yet another set of pieces. We can do that. We can do that. But now step back from this slide a little bit. Let's emphasize a few larger points. We've got some defaults in the law, where the law will say it's mine or it's yours. But in that default, all that the law will do is grant all rights to that one party. So first, if we want a different result, not you owning it, but me owning it, then we need to make sure that we attend to that through a proper transfer. Or if we want a sharing of the copyright and unbundling, we have to attend to that in a proper writing, in a proper instrument. And again, in both cases, this is where the contract comes in. Let's talk about it. The benefits of having a publication agreement: it can provide for, fundamentally, on our topic for today, a clarification of rights and a sharing of rights. It can do those two things in a way that the law cannot adequately accomplish. Defaulting to the law is likely to cause more confusion and more questions. So in almost all cases, an agreement is going to be an improvement, because the agreement can get us away from thinking about that dinosaur, the monolith of the copyright, and breaking it up and sharing it. The contract can help us get away from the confusion. Is it mine or is it yours? Work for hire. Is it mine or is it yours as my employer? And it can get us away from that and resolve the confusion that comes from those questions. So an agreement immediately on this point has some critical importance. So what should a good publication agreement have? Here are a few elements of a good agreement. It should have some kind of confirmation. If it's my agreement with the publisher, I wrote the article, the book, whatever it is I might have written, that it identifies that in fact I am the author, that it says so, and I'm willing to write that down and I'm willing to sign it. That might sound so basic, but it's really important. And it can be the opportunity for me to say, well, wait a minute, I got this picture from another source, I got these pieces from yet another source. It's a chance to sort out exactly what's what in this work. It's a chance through the agreement to confirm the copyright status. Who's going to be the copyright owner? Is it going to be me? Is it going to be you? Is it going to be yet somebody else? This is our chance, because through that agreement, we can effect a transfer to clarify where we want that copyright to end up. It's also our chance to maybe make a statement about the public domain, that maybe you don't want copyright for this work. Or maybe, one thing we haven't talked about, is it's not eligible for copyright. There aren't many things out there that fit this category, but one big one is works of the US government. If I happen to be an officer of the US government in connection with my writing this work, then there's no protection for that work at all. And the agreement is a chance to clarify that as well. It's also a chance to, if you can reach agreement with your publisher, to say something about Creative Commons or other alternative licensing. And we're going to hear more about Creative Commons later today. But essentially, Creative Commons is a way of saying, the copyright's mine, but I hereby share rights of use with the public. And it's a chance to let go of some of those rights that you have under copyright law. And for much of our world of scholarship, that's a good thing. The critical elements of a good publication agreement will be a license to the publisher. Now, conventionally, you'll often see a transfer of the copyright to the publisher. I think our move, and what we're seeing more and more around the world, is a tendency not toward a transfer of the copyright. You, the author, hang on to that, but rather a license to the publisher. And then that raises the question, so what does the publisher need? I guess at a minimum, some rights of reproducing the work, distributing the work, if it's a digital delivery, displaying it, transmitting it out via the internet. And so publishers do need some pieces of the copyright, but they don't need everything. They don't need everything. And as a result, here through the agreement is our chance to create a sharing model. And this is now a sharing between author and publisher. So now we're beginning to split up the copyright and move it around. and take the opportunity in a good publishing agreement to specify some rights that are retained by the author. And among those that are of great interest today are the right to be able to deposit a copy of this work in a repository, such as we have here at Columbia. The right to be able to meet your obligations under the open access policy from regarding funding from NIH, and we're going to hear more about that as well. And then the right to be able to use even your own work in connection with your own teaching, your own research, your own future endeavors. This is really important. And again, giving away the copyright under the traditional model undercuts even the author's ability to do good things with scholarly works. So back to our original question, multiple choice answer. Who owns the scholarship? Well, here's some possibilities. Which one is true? And we're going to get different responses in different situations. The legal answer, if we resort to the law, who owns the copyright? Who owns the scholarship? Well, I guess you do as the author. Oh, but maybe not. Maybe it's work for hire. Maybe it's something else. Now we've got confusion. Also, what do you mean own? Is it all mine? Is it all yours? Is there any kind of sharing? No, it's really an all or nothing proposition under the law. There's also a university policy kind of approach to this, where we could say that, in fact, there's sometimes that usually a university policy, as we have here at Columbia, reserves to the faculty author the rights to traditional works of authorship and scholarship. And that's conventional not only here, but at most universities around the country. But then again, there are always exceptions, as there are in the policy here and elsewhere. So we have some little bit of uncertainty there until we resolve it. And so option C, the better answer, the contract. The contract is a chance to resolve those uncertainties and come to the answer that actually serves us better. And then option D, what's my final answer? It's keep a copy. Whichever one of the preceding answers I picked, when you have an agreement, no matter what it is, I'll say this at every presentation, I'll say it over and over again. Any kind of agreement that you have with any publisher for the use of your material, keep a copy. Absolutely, positively, keep a copy. Remember how long copyrights last? Yeah, that long. A long time. Life of the author plus 70 years. The agreement is going to clarify the rights in that work for as long as the copyright lasts, for the life of the copyright, for the life of the author, plus 70 more years. Keep a copy. We need to see it. We need to see that agreement for a lot of decades to come. And so, thank you very much. Thanks to all of you. And I look forward to the next presentation and the questions and answers. Thank you.
Well, thank you very much. It's a real pleasure to be here, and I want to thank the organizers of this event. And the Scholarly Communication Program has really put on a really nice series of events, and I'm happy to be part of the closing event, although I hope that this is not the closing of the conversation about scholarly communication just for this academic year. Okay, so here's what I want to talk about. We will talk a little bit about authors and their individual ownerships of copyright, but I want to put that conversation in context of the larger information environment in which those copyrights matter. And I want us to think then about the information environment we currently live in, and think about whether, with the capacities of digital technologies, we might not fashion for ourselves collectively a more productive information environment for scholarly communication. So, quick question, and we have a young audience, so this one may fall on deaf ears, but how many people in the audience routinely recycled their newspapers and their plastics and cans 25 years ago? Couple of hands, right? Why? Well, part of it, it was hard, right? At the time, there wasn't curbside pickup. You had to bundle your trash on Saturday morning, put it in the car, burn some fossil fuels to go recycle your garbage. How many people today routinely recycle paper, plastic, and the like? Okay, almost everybody. Big change in behavior. How did that change in behavior come about? Well, it started with those intrepid individuals trekking to the recycling center on Saturday mornings because they had a vision of what the physical environment ought to look like. They had a vision about their role in this physical environment as consumers and people who then had waste that they had to get rid of. Right? So that was a vision that informed their behavior on Saturday mornings. Eventually that Saturday morning crowd said, there's got to be a better way. I don't want to have to do this alone. And we moved from individual leaders to more institutional solutions. Finally, governments get involved when you hit critical mass, and the institutions take responsibility for making this part of our environment and part of our activities. So I want to suggest that we're in the same process with respect to our information resources. And we're still at this early stage where it's the intrepid individuals who have a vision of what the information environment needs to look like, and are taking actions as authors, as owners of copyright, where copyright becomes an essential part of the existing environment that we have. And I want to make sure that the folks in the audience and anyone watching on the webcast are conscious of the current environment that we're in. So there have already been some noticeable changes. The move from print to electronic resources. Think about it from the author's perspective. If you're writing for a journal, how likely would you be to publish in a journal that published in print-only format? Wouldn't happen. Print-only distribution. No interest in electronic access. Your readership in that world is going to drop off significantly, and as we hear from Heather a little bit later, there are economic reasons for that, as libraries cannot possibly keep up with the costs of maintaining print subscriptions, and as publishers are creating pricing models that are pushing you into a digital environment. But understand the digital environment that we've got now. In a wealthy university like Columbia University, you live inside a very pleasant walled garden. Right? You have the computer there, you want to do research, you pull up, you click on a link to a journal article, and voila, it comes up. What you probably don't realize is that you passed through a toll gate that the publisher has on their database, where they check the IP address and say, oh, that's a request coming from a computer at Columbia University, I will serve up that copy. Right? There are folks outside the walled garden who, when they click on the link, they get the door slammed in their face. Okay? Because they're outside the wall and they can't afford to pay to get in. That's the current information environment we're living in, and I'm going to challenge you to make an argument for why that's a sustainable, desirable environment. And I want to argue to you that, in fact, there's a much better digital environment that we can have for scholarly communication that's economically sustainable, that's environmentally sustainable, and will improve the overall enlightenment project of scholarship and the transmission of knowledge. Right? And this is a good news story. We've all been terrorized by the climate change stories, and they're terrifying. Right? But I don't have to be Al Gore. I don't have to show you ice shelves falling off. I don't have to show you about the threat. I'm here to present you with an opportunity. Right? This is a world of opportunity to create a better, more exciting information environment. Right? And the reason I'm here to talk to the authors in the audience is because you're in charge. Right? Under the rules of copyright that Kenny just explained, copyright is automatic. This has been a feature of copyright law since 1710, where the author gets the rights. Right? So understand, you're sitting at your computer writing that first draft. You don't know it, but federal law is over there hovering above you. And the minute you save, federal law showers down upon you a set of exclusive rights. You are now a copyright owner. Congratulations. Right? And so the question is, what are you going to do with that copyright? And the standard story for copyright doesn't fit the scholarly author, or at least the scholarly journal author. Because the standard story is that the reason the law gives these exclusive rights is to give an incentive for the author to write this, because they need to get paid for their activity, and they will then transfer the rights to a publisher who will share the revenues the publisher makes with the author. That will stimulate the creativity. That's Stephen King's model, right? That's one version of copyright. How many folks in the audience have received a royalty check for their journal articles? No, that's not so the one-size-fits-all copyright story doesn't fit here. The reason that we can treat copyright differently in this space is because the motivations, the incentives, the economics are different, right? Researchers write for these reasons. It's about impact. It's about dissemination. So in fact, the walled garden is not in the researcher's interest, because it's going to be slamming the door in the face of potential readers, which is not in the author's interest. Okay. So, but we currently have a reason for the walled garden. The standard routine is author submits manuscript, gets a letter of acceptance, and then signs a copyright agreement. Or now some publishers have you click a little I agree button as you submit, and the copyright deal is done. Is it a fair deal? I don't think so, right? So here's one of the worst. A scholarly society, the American Chemical Society, the terms of the deal are, give us your copyright, we'll give you 50 physical copies. You want to distribute more at a conference? We do have a license fee for that. We will sell you back your own article, right? And we will sell it to your institution, and it ain't cheap, right? Okay. Why? And this agreement gets signed hundreds of times a month, probably thousands of times a month. Why? Because it's part of the routine. Just as it was once part of the routine to take that can of Coke and just throw it in the trash, right? It's now part of the routine that you just sign an agreement. And there's a reason for that. Prior to the digital environment, there weren't a lot of alternatives. That was the game in town. It was the only game in town. It was the only form of communicating with readers. So you just did it. It was part of the routine. Okay, but we now have choice. And when you have choice, ethical considerations, practical considerations change. So one argument I have, which is not appealing to many authors, is I think it's unethical to not read this and to just sign it, okay? Because you have a choice to renegotiate the terms of these, as Kenny was suggesting. This does not have to be the final terms of the deal, and they should not be the terms of the deal, right? So here's an example, and I want to make sure sometimes the open access conversation gets treated as if it's a science, technical, and medical publishing problem. So it's not. It's across all disciplines. And so here's JSTOR has become a repository for back issues of all kinds of journals, including a number of humanities journals. You want to see the walled garden, right? So I want this article. It's in JSTOR. Boom, $10 for one article. Right? JSTOR has to shut the door in your face as well, because that's their business model. Okay. We can watch TV for a little while, but eventually I'm too much of an egotist. I need your attention. What can we do to change, and why should we change? I mean, this is just, this new environment where there are new opportunities, and we've got, if I can get, but I guess that's all we can do, right? I mean, the publishers are there, they're in control. We got to give them control because they're the only game in town. There's no other way to communicate your research to readers anymore, but other than publishing it in that print journal and making sure it gets onto a library shelf. Oh, there is an alternative, isn't there, right? There is another way to disseminate research. The internet is there where as long as there's somebody with an internet access, then why aren't we giving the person with internet access to material that was written by an author who doesn't need to get paid to have written it, right? Now, there are costs involved in the publication process, and no one who's advocating for open access on the internet denies that, right? So a couple of points. I want to be clear. I'm now going to start using the word open access as the desirable endpoint in the environment. What I mean by what I mean by open access is the material is available for free on the internet, okay? That's the open access point. Nothing has changed with the publication process. It has still been peer reviewed. It has still gone through an editorial gate. Those gates are important, right? So I'm not suggesting we change those gates. It's about changing the terms of access, not the terms of publication. Another important point. Open access is sometimes associated with one particular business model that achieves the end of free access on the internet. That is not the sum total of open access. Open access means there's a file on the internet that anyone with an internet access can get to, period, right? We can now talk about the money side, how we're going to get that up there, how that's going to be environmentally and economically sustainable. But that's what open access means, right? And there are essentially two different ways to do that. One is to maintain the current subscription model, keep the folks inside the walled garden, give them their privileged access, they get instant access to the literature, right? And then with some minor delay, eventually the material goes up on the open web, so folks outside the wall eventually get access. Maybe 3 months later, maybe 6 months later, but ultimately the entire scholarly record belongs up on the open web. Okay, that I think should be a non-negotiable point that all universities need to grab onto. In the digital environment, the scholarly record belongs on the open web, okay? And we can sustain this, and we know we can sustain it, because libraries inside the privileged walled gardens still need to be on the cutting edge, still need to give their researchers instant access. They can't afford not to pay those subscription fees, right? So the system will be sustained by those subscriptions, but open access will remain the default for the long term. Okay. And this is good for researchers because you now can reach with open access 5 audiences that you don't currently reach. The first and often overlooked is the serendipitous reader. This is somebody who's inside a privileged institution with institutional access, but who might not be searching for your article in that mode. Instead, they're out doing a regular old Google search, they hit a blog that links you to another link, and suddenly you're linked to an article. I wish I had the details, I should have written it down. There was an NPR story. A medical doctor is working on a rare disease. He discovers that, or has an idea that he needs a drug that sort of turns a particular chemical switch. And then he thinks to himself, well, maybe some existing pharmaceutical product already has that property. And as he's telling the reporter the story, he says, so I went and did a Google search. I went and did a Google search to find the chemical properties of an existing pharmaceutical product. Researchers use Google too. If you're up on the open web, you will be found by the serendipitous researcher who's just doing a Google search, not the person who's inside the IP wall doing a search from on campus. So that's an important audience that you shouldn't overlook, right? There are plenty of researchers in your discipline who can't afford to be inside a walled garden. And as we're going to hear in a minute, the price of staying inside keeps increasing, and that's not because the costs are increasing, but because we've seen consolidation in the publishing industry, an increasing number of for-profit publishers who've seen that this is a fun and good game to be in. While the rest of the publicly held companies had a great year in 2008, right? But Reed Elsevier, Wiley Blackwell were happy to report nice little profits at the end of the year, while the rest of the market was down 25, 30%. There's a reason for that. But they've got to keep these under-resourced readers outside to keep the prices up. Okay, increasingly research has become interdisciplinary. Some of your readers are going to be in a marginal discipline, but can make use of the knowledge in your discipline and vice versa. So if I'm in an institution that only specializes in some disciplines, I'm not going to have access to the literature in those marginal disciplines. Increasingly, resources, are you confident that you know what the cutting edge research is going on in China right now in your discipline, in India, in Brazil, right? Probably not. Again, if we have all this stuff on the open web, we're going to be able to find out more what's going on in the rest of the world. To me, probably the most important class of readers is the machine readers, right? This is the most frustrating thing, and here I will talk about the science literature. Science information is in a Web 1.0 world. You cannot follow the links, right? You're reading a science article, you get the reference. Where's the link to the data set? Where's the link to all the other articles in the bibliography? Why can't I find those links and follow them? And it doesn't matter that it's not just that I want to follow them. I want to have a machine that can follow them and can analyze those links. Why does Google work? Google works because it analyzes all the links on the open web. It treats a link as a citation. It uses those for its ranking of relevant results. That's how Google works. You can analyze the links to buy shoes, to buy a computer, but you can't do that to find the article that might have the little critical missing piece in your research. And it's because of a technological impediment that we've tied ourselves to in this constrained digital environment. In an open digital environment, we can develop digital tools that will machine read the text, it will text mine, analyze the links, and help us deal with the information overload, help us find the needle in the haystack. And we can't even get that research started because we don't have the open code base to start that analysis on. So here's some statistics, open access. These are, when you get access to those additional readers, they do read and then they cite. I'm going to blow through these because I'm running out of time, but there is this other, and here's why I'm nervous about doing this, because opponents of open access say, I'm not going to talk about the principle of the scholarly record being available online. I'm going to instead turn this into a conversation about business models and talk about how it's impossible to have a business model in which, instead of having the reader side, the demand side pay for access, you have the supply side, the author or the author's institution paying. But there are journals that have switched to this model to give everybody immediate online access, and that is the key benefit of this switch. So it is an important switch. I don't want to diminish the importance of that principle. I just don't want to make that the be-all and end-all of open access. And when opponents make that move, I would ask you to call them on it, because it is not an adequate move. It is not an adequate response. But Public Library of Science is one of the leading science journals that has made this move. Its research articles have been reported in the New York Times and covered its cutting-edge research that is published, funded by authors' grants, made available immediately on the web, thoroughly peer-reviewed, very prestigious editorial board, and the like. Another one that's important, because humanities folks say, well, I don't get grants, so how am I going to do that? Well, the University of Michigan has come up with one model where we can fund the journal off the overhead fumes of the library. If you can read up there, it's edited by philosophers, published by librarians, free on the web. Right? There's no cost to the author to submit. There's no cost to the reader, because you've just got an in-house editorial board. Peer reviewers are all working for free. You can really push the costs down low when you're doing a digital-only publication. And so there are existing models, proofs of concept, that this form of open access is viable even in the humanities without grant funding. Okay. I think I've run a little over time, so I just want to leave you with the assignment. You've got to read existing copyright agreements. Make sure you look at what reader or what rights the author has, because to their credit, some publishers already divide the rights along the ways that Kenny had suggested. They give the author the right to put their final manuscript up on their own website, or maybe even in the Columbia Digital Repository. If you have those rights, exercise them, right? If you don't have those rights, negotiate to get them. I've written some standardized author's addendum that you can just stick to the author's contract, and I'll be happy to supply the links to those, and we can make those part of the record here. but also in the future, consider the access policies of the place that you're publishing, right? Figure out, I don't want to go through that hassle later on. So if you have two equivalent journals in terms of reputation, choose the one that's got the better access policies to submit to. Favor that. And there are a few other things to do, and I'm going to turn it over to Heather because it's time to move from the Saturday go into the dump to figure out how we're going to institutionalize these better information practices. And there's action happening. There are a number of institutions, funding institutions, Harvard, the Faculty of Arts and Sciences has come together to act institutionally, and Heather's going to bring us up to speed on all of those developments. So thanks very much.
Okay, so perfect lead-in. I'm intimidated, appropriately intimidated, and inspired by the first two speakers. So hopefully what I'll be able to at least attempt to do in my time here is A, use the mouse properly, and almost there we go, and reiterate some points that both Kenny and Mike made, and then also give you a little bit more concrete guidance on, okay, now how can I go ahead and do the kinds of things that both Kenny and Mike suggested that I do to adequately manage my copyright to ensure that the results of my research or my scholarship has the broadest possible downstream use, distribution, and reuse that I want it to have in the future. As Kent mentioned, the organization that I represent is called the Scholarly Publishing and Academic Resources Coalition, which is why we always go by the acronym SPARC. Even I can't remember that as a full name even on my best days. What SPARC is essentially a library membership organization that was founded about 10 years ago, and it was founded to be a catalyst for action, to try to find concrete actions that scholars, the library community, and the academy as a whole could take together to move from the current status quo of a system that's still mired in so much of the ecology, as Mike said, of a paper-based communication system, and to try to move it to take advantage of the tremendous opportunities that are provided by this new digital networked environment that we have. And I want to be really clear. SPARC, as you can see from our homepage, Open Access Advocates, the idea that we're working towards is the idea that Mike described. We believe that scholarship should move to a form where the distribution of scholarship is freely available on the internet. And we're talking about that subset of scholarship and science that researchers and scholars have traditionally produced without expectation of payment, right? Very important. We're talking about journal articles, monographs, where authors have been unpaid, and we would like to see that kind of scholarship, the ownership of that scholarship and the distribution of that scholarship be put more closely back into the hands of the scholars that produce it so that you can control its downstream destiny as best as you can. We're not talking about this issue as an issue that's punitive to publishers. Right? There are a lot of publishers that are kind of coming along in this world and trying to make this happen, right? Trying to enable the broadest downstream distribution and reuse of this material. So when we're talking about this, I want to emphasize that we talk about understanding, exercising, and managing your copyright as a way to leverage the opportunities that are put in front of us by the internet, allowing us to distribute our scholarship to a much broader audience than we ever would have thought possible at virtually no marginal cost for each additional issue. We don't have to worry about press setup and paper mail and binding, shipping charges all over the world anymore, and yet we still think about that. We're still stuck in a system that has so many of those little vestiges in different parts of our scholarly communication system. So we're talking about really coming at this problem from the time when a scholarly article is created. It's pretty incredible that 15 years after the internet really has been in popular use, we see that scholarly research articles are still so often only available to a small fraction of the community of potential users. And the reason why is no secret. And Mike did a good job, I think, of describing the fact that scholarly journal prices, scholarly journals are expensive, and particularly in science, technology, and medicine. I didn't put a slide in that I normally do because the slide's getting a little bit outdated, but it shows a 20-year history of journal price increases compared to the Consumer Price Index. And I realized I don't actually need to put the slide in because I can do this, and I call this my open access modern interpretive dance. The journal price line on the slide looks like this. It goes straight up in the air, and over a 20-year period, it increases at about 260%. And then the consumer price index at the same time goes like this, sort of off into the distance at a nice sort of steady 41%. What we have in the middle here, dance part of the show, is a gap in access where people cannot afford. When your library budgets are going up to keep pace with the rate of inflation, and journal prices are going up at this rate, you can't afford access to all the materials you want to provide your audience. What ends up happening is that means your work isn't being read, isn't being seen, isn't being used by the amount of people that you want it to be seen by. So the result has been for this new kind of framework that allows us to take these access barriers down, to let these people in the middle get access to the work that you've created, and to allow your work to be not just accessed as freely as possible, but also to be more fully used. So how do you go about ensuring that your work can be accessed and used more as fully as possible? Well, I think Mike started to give you a laundry list at the end of his talk about things that you should do. Reading the copyright transfer form for a journal, understand before you make a decision in which journal that you want to publish your article is the most important step. And the copyright transfer agreements tend to look like this. They're 1 to 2 pages. They have very basic components. If you look at them and you want help in dissecting, well, what does this thing actually say? What I really am interested in doing is being able to put a copy of my article after it's published on my own website or in my institution's repository, or my funding agency says I need to do something in specific with my article. How can I figure out what this copyright transfer form actually says? Well, reading it, is always step one. I'm not a lawyer. Sometimes I get stuck on these copyright transfer forms, and I was a journal publisher for 15 years. So I would suggest that there are resources available on the web to help you interpret these. This thing is just zipping along. To help you interpret what these copyright forms are actually asking you to do. So there's a resource, for example, called the Sherpa Romeo website. And this is a compendium of publisher copyright policies. And if you take a look at it, you can search for the journal you're considering publishing in, and it will tell you. If it's got a little green check mark, it allows you to archive or to post on a website a preprint of the article that you want to publish or a final copy of that article. Say you are, it just keeps hopping along here. Say you are a physicist, and you're interested in publishing in one of the journals of the American Physical Society. Well, this looks pretty good. You go to Sherpa Romeo, you type in American Physical Society, and this tells you, this publisher's got some pretty good practices. It allows you to post that preprint, that postprint. It's compliant with loads of the policies that intersect with copyright in that discipline. It's great, it's free to read. You can click on the view policy and see what the policy actually looks like. That's terrific. Say you are, however, sorry, you would think I never used technology before. But say, however, you want to publish in a journal for the American Psychological Association. You type in American Psychological Association and you'll see. While there are a few things you can do, there are lots of things that you can't do with this article. Lots of policies and things that intersect with what you may want to do with this article down the pike that you see big red X's through. So this site is a really good way to help you as an individual author understand what's possible to do, what it is possible to do with your article once you decide to publish in a specific journal versus another journal. If you're one of the the unlucky authors who says, well, gosh, I got a grant from HHMI, the Howard Hughes Medical Institute, and I really wanted to publish in the Journal of Clinical Psychology, for example, but there's a red X through my the HHMI notice that says that the APA will not allow me to comply with what HHMI wants me to do, which is actually to take a copy of my final manuscript and make it publicly accessible via a publicly open repository. What do I do? What can I, what are my options there? Well, of course your options could be to look for another journal, but say this is the journal you really want to publish in. You're not stuck. You can actually consider doing another thing that Mike suggested at the end of his talk. You can consider amending that copyright transfer form, right? Kenny was very clear in saying copyright is a contract. It's something that can be negotiated, it can be amended. There are lots of tools out there for individual authors to turn to say, okay, I I really want to be in this APA journal, but I've got an HHMI grant and I need to do something in something specific. You can look at the Science Commons website. You can look at the Spark website. You can do a Google search for something called an author addendum. And on all of those sites, you'll find legally vetted tools that are just little pieces of virtual paper that you can use to append to any traditional journal transfer copyright agreement that you can say, I'll transfer all of my copyrights. I simply want to reserve the right to be able to post a copy of my final paper in the HHMI required website, or any one of the other rights that you might want to reserve. The point is, there are these tools available in multiple forms for you to use. The Science Commons website, I'm going to recommend, not over the Spark website, but I think the Science Commons website has a really great little online addendum generator where you can type in what it is you want to reserve the right to do, and it will customize and generate an addenda for you to use in these circumstances. So that's one reason I think that it's important for us to pay attention to copyright. Right? You want to make sure you have the best choice of journal outlets to publish in. You want to make sure this work gets out there. And what's more, you and we are operating in an environment which is moving more towards the green environment that Mike envisions, and that we do live in now, or we live more in the recycling era. Within scholarship, our academic institutions are recognizing that access gap, right? While it seems like these are just numbers, right? The journals are expensive, and they're increasing at a rate that doesn't keep pace with inflation. Yeah, it's not a great thing that scholars don't have access to it, but what does it really matter? Universities are increasingly recognizing that it matters a whole lot, that it's really affecting the core mission of academic universities and institutions of higher education, which is to disseminate and convey knowledge. That if people can't get access to the intellectual output of your university, then the university isn't achieving its core goal. So what we're seeing happening is that universities are actually taking action, and they're taking action around making sure that they're closing this gap, that they're narrowing this gap of people's ability to access this information, and that they're also boosting their position to be able to bring forward the results of the intellectual work done on their campuses to as wide a world as possible. Mike noted that Harvard University was one example of this, and I do want to say Harvard is the first example of this. Last February, the faculty of the College of Arts and Sciences of Harvard University voted to essentially make open access the default mode on campus. And they went about doing this in terms of putting a requirement that any faculty member in the College of Arts and Sciences that produces a scholarly article agrees that they and the university will retain a non-exclusive right to distribute that article via Harvard University's digital repository. So they're essentially looking at this as a permissions mandate, right? Retaining the copyright on campus to ensure that the works of all of the faculty of arts and sciences at Harvard is distributed in these digital repositories to the widest possible audience. The lovely picture is Stuart Schieber, who was the faculty leader who helped develop the policy and push this vote through the Faculty of Arts and Sciences. On Harvard's campus, the law school and what's the other school? Kennedy School of Business, thank you. Government, just have followed suit. Stanford University School of Education has passed a similar policy. MIT, just a couple of weeks ago, passed a similar resolution. Boston University has put a recommendation for their faculty to consider doing the same thing. Texas A&M, Oberlin College, Trinity University, these discussions are going on all of these campuses about taking a similar role in terms of a permissions mandate, copyright-centered, to ensure that the intellectual output of the faculty on campus has that broadest possible downstream life. And the other reason that the copyright is important to you is in sort of a larger, sort of more global ecology, is that it's not just campuses who are recognizing, not just institutions of higher education that are recognizing that this is a powerful tool for ensuring that our research gets out there. increasingly, we're seeing public funding agencies and private funding agencies, but public funding agencies in specific, moving towards implementing policies that use copyright and the retention of copyright and the requirement for depositing a manuscript, an article, in an openly accessible repository at the center of their policies to be able to maximize their investment in scientific and scholarly research. And this is just a quote that encapsulates the policy discussion that's been going on all over the globe. This came from the International Organization for Economic Cooperation and Development, the OECD, that noted back in 2005, when they were looking at this idea of how do you ensure that the research that you're investing in, that investment is leveraged to its fullest possible extent, they realized you could do that by doing one very simple thing, by ensuring that the results of that research can reach the broadest possible audience so that it can be built on, right? It's just an explicit recognition of the cumulative nature of scholarship and of research, right? We can only advance our disciplines and only leverage our investments in science and scholarship if what came before is available for this generation and the next generation of scholars to build on. And so we've seen very visible iterations of this kind of thinking come out in the last couple of years. Most notably in the United States, we see the largest public funder of research, the National Institutes of Health, which has a $29 billion annual research budget, now have a requirement that if you as a researcher take grant money from the NIH, you are required to do two things. One, to make sure you retain sufficient rights to comply with the policy, to know up front that if I take this money from NIH, I'm going to be required to deposit the final version of any article accepted for publication in a peer-reviewed journal into an open access digital repository at NIH, right? So it's, again, the twofold thing, a permission mandate. This one's more of a deposit mandate with a little permission function on it, but again, centering around making sure that you as the grantee are aware when you're writing that article and submitting it, that in order to be in compliance and to give this research the life that it deserves, that you successfully manage your copyright. And finally, let me actually say that. Finally, I'm going to talk a little bit about why it's important in terms of how to characterize this in a politically correct way. Not everyone agrees that the open access world is the world that we should be moving towards. And in particular, the journal publishers who have traditionally charged extremely high subscription prices, right, that have us up here in the stratosphere, have fought very hard against the idea of this broad distribution. Not because they're against the idea of broad distribution, but because this broad distribution cuts into the profits that they have for their exclusive perpetual distribution license to your work. Right now, there's no way in a subscription-based environment for anybody to get access to the results of most commercially published research without paying a subscription fee or an access fee now and into perpetuity. In an open access world, that barrier is removed. And so the ability of publishers to reap these large profits into perpetuity is limited severely. But what we're seeing is, because scholarly publishing is such big business, right, we're talking about profit margins that reap publishers, particularly in STM, upwards of $6 to $7 billion in revenue per year, billion with a B. It's huge business. So market analysts cover the scholarly publishing marketplace quite thoroughly, and they've recognized that there really is a battle going on right now where policies on the one hand, like the Harvard policy and the NIH policy, are coming out that are encouraging authors to manage their copyrights in a way that makes their work more openly accessible. But on the other hand, there's a pushback from the publishing industry to try to keep control of these copyrights. This system's working very well for commercial publishers, thank you very much, and they don't want to change it. Exxon, BNP Paribas, for example, last year in an analysis of the scholarly journal marketplace, noted something that I think is really important and shows why copyright is really at the center of this battle for control over dissemination. They noted that in their view, the economic model of journal publishing is really based on selling access to an aggregate of non-proprietary academic content. And they understand that while if you sign it over, the publishers own the exclusive publishing rights of scientists' work, we don't share the view that they own the intellectual property of that work. You would think that that would be pretty obvious, right? Well, unfortunately, there's a bill in front of Congress right now called H.R. 801 that would actually amend copyright law, that would create a new class of copyright protected works, largely in favor of the publishers, that says that if an article has been essentially undergone the peer review process, that the publishers can claim ownership, copyright ownership of the article even earlier in the process. So this is a really active area, and it's a really important area for scholars to be aware and involved and actively engaged in learning as much as you can about how best to ensure that I'm a mom, so I always come back to this analogy that, Mike talks about copyright being showered down upon you. I always think you produce this article, it's kind of like you're putting your baby out there in the world, right? Your little research article out there in the world, and you want to make sure that all the possibilities in the world are available to your baby as it grows up in the world. And I think of scholarly articles, I know it's corny, I think of scholarly articles in that regard too. So I think, my takeaway from this would be for us to be conscious producers of the articles that we're putting out there, and to think about the actions you can take from the inception of that article to ensure that your scholarship can be accessed and then used in all of the ways you might envision for not only yourself, but for future generations of scholars. I'll close by just putting a screen up here. In the introduction, I was noted that I am the executive director of SPARC. SPARC also convenes a larger umbrella group of people who are interested in the idea of open access, but from the public perspective. If you're interested in looking at any kind of political activity around ensuring that bills like H.R. 801 don't get off the ground, you can take a look at the ATA website. We work specifically on the subset of scholarship and research that's been funded using taxpayer dollars. So I'll stop there because I know we probably have loads of questions from the audience on this. So thank you.
While they're getting set up to answer questions, I wanted to point out that it's important to remember these things are not mutually exclusive. You can still get an income stream even though you're putting stuff out in a repository. For example, I was just looking at the books of a small law journal in a law school, and even though they basically publish by putting material on a website, they also allow aggregators to take their material and serve it up through their aggregator services. And they get a quarter of their income through royalties from that process. And so the notion that one kills the other is a totally false, overstated notion, I think. So questions for the panel?
What is being done to stop plagiarism and identity theft?
Anybody?
Well, yeah, I mean, you do realize that's a totally different question from everything we've been talking about. You realize that?
Plagiarism is relevant.
Yeah, tell me what you're thinking of. Please, help me out here. Tell me what you're thinking of.
I have nothing more to say. I think this.
Can you give us an example of what concerns you?
Yeah?
Yeah. Go ahead.
Suppose a certain scholar writes an article or a book, but the work is published, perhaps after leaving the university, and then somebody else takes on the same position that the scholar had, perhaps uses her name or his name or doesn't, but anyway claims authorship, or in effect claims authorship of the piece.
Well, I mean, that's just a risk that exists in the scholarly environment, and nothing. So that risk doesn't change whether the access is open or not. Again, I would argue if we had machine access to the literature, we could actually use the machines to help detect that kind of plagiarism better, which is what the Turnitin service tries to do with student plagiarism. So again, that would, for me, be an argument for web. If we had a Web 2.0 information environment, we'd have tools to help deal with that problem better. But I don't think open access. I do think it's sort of orthogonal to what we're talking about here.
Right, and I'll just add a little bit too to frame the issue. You know, if they couldn't pick it up on the camera, the question was about plagiarism and identity theft. Extraordinarily important issues. Starting with plagiarism. Plagiarism is the issue, as you did describe in your situation, in your example, of a situation involving fundamentally not giving credit where credit is due. And that really is separate, just to get to the structure of the issues. It's separate from copyright, in that copyright is about the rights associated with reproduction, et cetera, of the work, not necessarily with identifying the source of the work. And so identifying the source is extremely important. It's fundamental in the academic environment.
May I say one more thing before I have to leave?
Yes, you may.
Thank you. Regarding the use of code, machine code, as you said, I don't know your name.
Michael Carroll.
The use of machine code can also increase opportunities for thieves and terrorists to do harm to individual authors and to institutions. I assume you thought of that. I don't think the bankers did.
Thank you very much.
Who's moderating?
Hi, my question is basically, I know many universities have issued statements saying they take the position that academics own the copyright in their scholarly works, but from what Dr. Cruz, you were saying, it's not clear to me that that is able to override the work for hire clause in the Copyright Act, and that universities do not actually own the copyright. So I'm hoping to get more clarification on that.
Are you a law student?
Yeah, actually not.
You know, this is great. You asked a brilliant question, and it really is a complicated issue. In an ideal world, you are absolutely right. If that work, pick anything, a scholarly article, teaching materials, a lab report, pick anything that is copyrightable, that's created by any one of us, that if it is work for hire, let's just take that if to avoid the details. If it's work for hire, can we, as I outlined, transfer that copyright back to the individual author? And the answer is yes, we can. But you're quite right. I moved quickly through it, and I think you caught it, that a transfer of the copyright really must be in a writing signed by the party doing the transferring, which leaves open for future debate, litigation, lawyers making lots of money, that the question of, well, wait a minute, does that policy in the policy manual really accomplish what it purports to do? And we do have some court cases on that are really emphasizing that question. We do need to take a fresh look, and I would say this, and I have said this, to individuals, to universities, if you've got something that you really need to nail down and you see dispute on the horizon, there's enough at stake, you better get the parties at the table, write it down, and get them to sign it. Now, is that realistic in the routine environment? No. But, and are people likely to dispute that in the routine case? No. But if you've got the not routine situation, you better get the parties to the table and write it up and sign it.
Yeah, from the lawyer's perspective, this is an interesting situation because the entire discussion is built on a very rickety foundation. And it's basically because there was a change in copyright law. Prior to 1976, the work for hire doctrines had a teacher exception where because the work for hire was...
I would even dispute that.
Yeah. Well, the courts had created the doctrine, and so they could create their own exceptions, so there was a lot of fluidity in it. And then in 1976, Congress says, we're going to write it down. And they wrote it down just saying, if you're an employee, it's in the scope of employment, your employer is the author. So as long as we would agree that a scholar writing an article is in the scope of employment, then the flat text of the law says the university owns it. But lawyers, we have interpretive methodologies, and we can, right? So it's not at all clear that that's actually what the law is, and it's unlikely that any party in the system as it's currently configured has the incentive to bring this to court and seek a final resolution. But there is a potential ticking time bomb under the whole scholarly journal publication, right? Imagine suddenly the Supreme Court rules universities own the copyrights of every journal article ever written by their researchers, right? It's a theoretical possibility, but the possibility of that ever becoming someone investing in the litigation, I just don't see it happening.
And you know what would be great? The result of that, though, is suddenly all those copyright transfers signed by authors would now be potentially ruled invalid. Right. And now we would just blow up the copyright ownership of the entire system. That'd be kind of fun.
I'm sensing a weekend project for Kenny in the future.
Got nothing else to do but sweep the floor.
Is that a question there?
Hi, I have a couple of questions. The first is, how does any of this apply to graduate students in the university? So for instance, if you produce something and, let's assume that there's going to be some kind of tension between the work for hire concept and, author ownership, right? Does it also apply to graduate students since they're technically not university employees? That's question one. The second is, especially for journals that have, like some of the ones you were showing that have less favorable copyright contracts with the author than APS journals. What happens with software? So suppose you've written a piece of scientific software that you intend to distribute as open source, but you describe the algorithm and maybe even pieces of the code itself in a journal article that you then submit to a journal that has less favorable copyright agreements. What trumps?
Laura, you want to take that?
Two really good questions.
Yeah.
Which one do you want to do?
Well, you're an employee of the institution. You should probably talk about the patent issue, and then
Would that be the software one?
Yeah.
Yeah.
And then,
I'll give it a try. I'll give it a try.
Talking about something you intend to distribute as open source, so you're not intending to try to monetize the software.
right. But under the policy, are you allowed to make that decision?
Right. And when we talk about the policy, to get to what I think is the kernel of the question, if your article, your copyright protected article, includes lines of software code, who owns what with respect to that software code once that work has been published? I'm going to give you the most important answer I can up front. You want to know what it is? It depends what your contract says. How's that? So you've got a situation that I would say you need a very carefully written contract. Before you publish that article, get the answer you want laid out in that contract. Now let's put that aside for a second. There would be the better answer. Under a typical arrangement, the copyright in your article itself explaining the code is going to be yours under at least the policy, if not under the law. Then maybe you've transferred that over to the publisher. I hope you haven't, but maybe you have. So what we're talking about in all of that is the copyright. What about if the lines of code, which could be copyrightable, and maybe they've now flowed with the article, but they might be patentable? In that case, if you have a patentable invention that you create here at the university, even though it's articulated inside of a copyrightable article, you have a duty to disclose that to the proper office, the technology transfer, or other proper office at your own university. So you would disclose that there, and that would be sorted out. In a typical publication agreement, especially in the science field, it will say, many of them say, even though you're transferring the copyright or something equally overreaching, we still leave with you the patents. So patents are often singled out in these agreements and left with you. And then if you're part of the university, you're duty-bound to report that to the university. That's your typical way that those pieces would flow. I hope that's helpful.
It is, but I guess the crux of my question is going the other way. Suppose you don't want to patent something. Suppose you write some piece of software.
Yeah.
It's going to be useful to the community that you want to distribute as open source, right?
Right.
But you've also published the algorithm and potentially some actual pieces of that code someplace else, and you have one copyright.
So hang on. More detail than I can handle.
Well, can I try this? I got this. And I don't think everyone heard. So the thing is, there are two copyrighted works here that are then mixed. There's the copyright and the software. So the problem is the software is both potentially patentable and a copyrighted work. Let's just talk about it as a copyrighted work of authorship. And then there's the copyright in the article. But the article reports a little bit of this as well, right? So this is an open source. That means it's under a copyright license that says you can do anything with this subject to some. Are you doing GPL, BS? Okay, so it's under a copyright license that basically says you can do anything you want with this, but if you make a derivative work from it, you have to license your derivative work under the same license you took my pieces of code from. So it's an open license. It says take it, go for it. But now if I put that into this copyrighted work and I tell the publisher I'm giving you the rights to this copyrighted work that's got these few pieces that are already licensed under different terms, now there's a potential conflict between the copyright terms of this work and the copyright terms of this work. It definitely depends on what the publisher's agreement says, depends on how many lines of code, I mean, because there are exceptions. It's so that if it's only a few lines of code and it's the algorithm, you know, it's not clear that that's even enough copyrightable expression to trigger the problem you've posed. But it is the problem, the more general problem of I've written this work, I own a copyright in my expression, but the total amount of expression includes stuff from other places. So art history has this problem all the time, right, of what do we do? And usually the publishers in those disciplines have in their agreement some clearance, you know, you represent that I cleared the rights, and in this case you're both copyright owners. So you say, yeah, I got the rights from this guy to publish it in here.
Yeah, that's exactly right. And if you're talking about including those lines then in your article, I mean, remember I mentioned third-party material at some point in the presentation. Yours is like that. In some ways it's a little different from a quotation from another source, except it just happens to be governed by a license term that makes it open source, which is even better, you know, because then you may not have to worry about fair use or anything else. It's already allowed for public disclosure. You could be fine.
Yeah, I think.
What about the other question, Brad?
Well, I mean, so it's the same rickety foundation, except now you're not. But I think it's stronger that you must own the copyright, unless, I mean, the university might have a policy that says we get a license, but I don't think that they can claim ownership in any way.
It would really depend on, your question was about, you write an article in your capacity as a graduate student. If you're not writing it in your capacity as an employee or subject to any other contractual obligation with respect to that work, then it's really going to be yours. I mean, if you're saying, I'm a graduate student and I wrote this article or paper as part of my requirements of earning my degree, that's why I wrote it, it's yours. It's yours. So it's up to you to manage as you see fit.
Subject to the patent policy. I mean, because anytime you write an article that discloses a potentially patentable invention, most universities have a policy that governs that requires even graduate students to disclose that to the university. The university may claim patent ownership, but that's like a separate panel.
And exactly, yeah, big issue.
Was there a question?
Is it on? Okay. I don't have a question about terrorism. It's a hard act to follow.
Thank you.
I wonder if we could drill down on this work for hire concept. I imagine you don't have to be an employee to be doing a work for hire. You could be a consultant. I imagine you could be writing something without being paid at all if you are writing for a scholarly journal or something like that, or an association, and there's some kind of a quid pro quo.
We're so glad you're here.
Okay, and I'll stop now.
Okay, everybody pull out your books for responsive readings now. We're going to do this right. There's a fairly straightforward answer to your question. There are two varieties of work for hire. One occurs far more often than the other. And so that's the only one that we've mentioned so far. And that is, am I an employee, not an independent contractor, not a volunteer? Am I an employee acting within the scope of my employment? Now, lawyers have made a lot of money debating what those words mean, but those are the words. And if your answer is, yes, I'm an employee, yes, it was within the scope of my employment to write that piece, create that work, produce that website, it's work for hire.
Unless there's a teacher exception.
Yeah, whatever that is.
Right.
Then there's a second variety of work for hire that does apply to independent contractors. So now we brought somebody in, gave them X number of dollars, said, produce this website and go away. That's an independent contractor to come in, get the job done, and leave. But the work for hire in that context applies only very narrowly. The first thing you have to have, remember the first one was employee within the scope of employment? That means it could become work for hire by circumstance. And presto, it's work for hire. You weren't thinking of anything, but it was, because you fit in the category. But the second one, where it's an independent contractor, you can't get into it by accident. It requires a written agreement signed by both parties that includes the magic language that this will be a work made for hire. You can't get there by accident. So which means when you hire that person to come in and do your video production, your website development, your software development, whatever it might be, you better, and you want it to be a work for hire, you better get an agreement that has the magic language. Plus, to make it even narrower, it only applies to certain types of works that are on the list in the statute. And there's a really good chance your work is not on that list. So you can't make it work for hire even if you tried. So what do you do then? A transfer of the copyright, if that's what you want, or a license of the copyright, if that's what you want. So you're back to a management issue about how to manage the copyright and the bundle of rights, and how do we get to a good, equitable result out of all of this. That's where we should be headed.
And can I just, one quick thing, because sometimes people, work for hire just means the author, the employer gets treated as the author. But it could also, I mean, you can also just give away or assign the copyright. In either case, the employer owns everything. Now, there are differences down the line about what happens depending on those legal treatments. But an important point is, in either case, in the independent contractor case or the transfer of copyright, you do need a written agreement signed by the author. So one way to do open access through the back door is passive resistance, right? You just don't sign the publisher's agreement. What's the legal effect of not doing that is you actually retain the exclusive rights. You can't give the publisher exclusive rights except through a written agreement. So if they never ask you, if they never press the question and you never sign it, the publisher has a non-exclusive license to, they have your permission by conduct, because permission is easy to grant. Exclusive rights are difficult to grant. That's the design of the statute, to make sure the author is consciously let the world know that this is a transfer. So in that second category of work for hire, you need the signed agreement as well. So either by transfer or by work for hire, outside the employment context, you need a signed writing in order to give exclusive rights to another party. Good.
I have a question. I have a question for Spark.
Okay.
Here's the question that we get at faculty meetings all over the university talking about these issues, and I'm eager to hear your response. Common question: isn't this open access movement going to kill my favorite journals? Isn't it going to be the death of the journals that we're counting on as an important vehicle of communication, as an important standard of quality in the scholarship of my field?
So we get that question all the time, right? We get that question from faculty members, we get that question from publishers, we get that question from members of Congress. And the answer is no. I mean, there's nothing in the model or the models that can support a transition to open access publishing that will say traditional journals can't make a transition from a subscription-based model to an open access based model, or that new journals that are just as prestigious and just as rigorous in terms of quality control can't be created, born out of born into an open access model. The real worry that I think publishers have, and I think publishers have a legitimate real worry when they're talking about transitioning from subscription access to open access, is they've relied on a model of doing business for, many of them for multiple decades. The mode of journal publishing has moved from a balanced portfolio approach of revenue streams supporting a journal to the vast majority of revenue for any individual journal, upwards of 85 to 90% of the revenue that supports the average scholarly journal comes from institutional library subscriptions. So publishers have really moved into this, putting all of their financial eggs in one basket, and the basket comes off the backs of libraries. So whenever you're talking about moving to a model that says, we're not going to collect subscription money, and 90% of my revenue is coming from subscription money, you can see why publishers panic. I mean, why the concern is, what the heck do we do? The reality is that there are lots of different kinds of revenue streams that some journal publishers do employ and that most journal publishers can employ in order to support an open access model. A lot of journals, scholarly journals, for better or for worse, employ author charges, whether they're submission fees for a journal, page charges for a journal, charges for any kind of a service that the journal provides that an author would value and would be willing to pay some money for, either out of their grant or individually. A lot of journals, particularly general interest journals that are heavily trafficked, get revenue from advertising. That's another little slice of the pie that can be used to support it. Some open access journals and traditional journals employ sponsorships from commercial companies. There's a large sort of number of little sources of income that can be used to supplement the money that comes from the current university library slice of the pie. What we're seeing in terms of the sort of maturation of business models that are being employed to support the open access movement is that the funders of basic research, the people who are paying money to do the experiments in the first place, are beginning to explicitly recognize and to state, if I fund you to do an experiment or to do this scholarship, and you can't, don't, or won't communicate the results of what you found, that experiment is really only half done, and I really haven't gotten what I've paid for out of this investment in the research. So a lot of funders are explicitly now starting to set aside money for the communication of the results, and that can be employed and deployed in lots of different ways. However a publisher wants to collect it through an author fee or a sponsorship fee, that's a pot of money that can be used. We also see institutions like Harvard that are saying, if we're going to require, right, if we're going to require our faculty members, or if our faculty members are telling us, as a more accurate read of that they want their material to be available in open access outlets, then we as an academic institution, not just a library, but an academic institution, are going to look into creating a fund that comes out of the institution for helping to support the distribution in an open access model of our scholarship. So we begin to see the little threads being woven together into the safety net that can support an open access system. Will some journals not make the transition successfully? Yes. I mean, I think that's reality, that this is a seismic shift in a market where there are strong players and weak players. Some of the weaker players will not make the transition successfully, but I don't think there will be a mass extinction of journals because of some fatal flaw in economic models, potential economic models, to support the open access movement.
If I can add to that a little bit, there are lots of librarians who would love to see lots of journals die. There are a lot of journals that
I didn't say that, I want you to know.
Pointless, and publishing stuff that have been rejected by other journals.
Yeah.
And so if, in fact, we do have a Precambrian death, whatever you want to call it, that would be great.
One thing I think is really important that's happening now, like I usually do talks about open access, not just strictly copyright. And when I talk about open access, I talk about the point where we are right now. 6 years ago, 7 years ago, we started talking about open access as a concept. And we've moved from this sort of theoretical construct of wouldn't it be nice if, where there was a handful of open access journal publishing outlets for authors to publish in, and a couple of digital repositories if you couldn't find, when you couldn't find a journal publishing outlet to put your manuscripts in. There's a directory of open access journals that now lists 4,000 open access journals in disciplines from A to Z from countries around the world. There's more than 1,300 open access digital repositories if you just want your article to be openly accessible and you don't want to go through the open access publishing outlet. And yet when I give those statistics a lot of times on campuses, one of the questions I get back from faculty members are, well, those 4,000 journals, how many of them are really good? And I turn around and say, well, how many subscription access journals are really good? I mean, you look at the ecosystem, we're starting to build a parallel one in the open access world where it's caveat emptor. You need to do your research on the journal. Look at the editorial board. Exactly what you would do in a subscription-based environment to make your choice. But the point is, we have a choice now. So in sort of 5.5, 6 short years, we've gone from just a few to really this parallel universe that's on the verge of merging with the subscription environment and hopefully overtaking it.
Mm-hmm. Kenny, I just got a bill about 3 weeks ago for a journal that's special. It's for financial analysts that we get in the law school library. Now, this is a field that has basically led us down a very bizarre path and contributed to the depression that we're in now. And they are asking for 66% more for next year's subscription.
Wow.
I would dearly love to say, if I didn't have this being rooted to a couple of professors, I would say, oh, let's just cut them off now and let them receive a signal. I have asked questions at Law Librarian Association meetings saying, when are you going to cancel the journals or the books that only 5 people are buying? Nothing seems to make publishers think that they should stop publishing something. And that's what I would love to see happen.
Right.
Is some publishers say, this just isn't worth it anymore.
Well, I worked for Elsevier Science. That's my one disclosure. I worked for Elsevier for 11 months, I want you to know, out of my 15-year publishing career in the not-for-profit world. And I quit Elsevier because the business model, there is something that will make us kill journals. The business model for journals, my title was acquisitions editor. So I thought, maybe I'm here to start up new journals, buy new journals. Buying new journals was the operative mode. I had a list of spreadsheets of 11 journals that were all munged together, and of those 11 journals, those spreadsheets, I had a target revenue number that I had to make at the end of the year. My revenue number on these journals, these 11 journals, it was like $3.6 million. These were linear algebra and experimental math journals. What I had to do was try to find a way to manage these journals to make that margin at the end of the year. And if I didn't make the margin, I didn't have a job. So what do you do to make that margin? Well, you look for ways to cut the manufacturing costs of the journal or to bring in more money. And when you only have one source of revenue, the only way to bring in more money is to raise the library subscription. So the dance was, which journal were you going to raise by what percent, in your collection of 11, and where were you going to skimp or scrape or save money in manufacturing costs from doing everything like print more words on a page, so the gutter width in the middle of the journal I would try to squeeze as small as I could, cheaper paper, less, get the authors to print fewer pages in their articles. But that was really the dance. It was try to save money on the manufacturing end and then make up what you couldn't save by charging libraries more. And the net effect on the journals would be that the higher I raised the prices, the fewer subscribers I would have. And when my subscriber base got down to, which many of them did, 300, that was a little red flag that would come up in your computer system, and it would say, now you're supposed to go out and look for a new an organization, a society, or a group of editors that would be willing to start up a new journal, because that one's going to die. It was a death spiral model of journal publishing, and that was what I was expected to do as a publisher. I mean, I cried and I quit, but I also started doing this because that's not a model that serves scholarship. You know, you price people out of the marketplace, and we have our access gap, you know, as we price people out, but you also kill perfectly good scholarly vehicles that way.
So I want to ask a question of the audience, because I want to understand Columbia University in this environment. Is this a university that's interested in having a leadership position here? Because Jim Neal, the university librarian, has been one of the most forward-thinking folks on open access. So the university libraries here have gotten this for a long time. And they've gotten this, it's not just about subscription fee. It's about what is the role of the university and why is open access an essential part of the university in the 21st century. So it's that level of vision that this institution has had. But I don't sense that the faculty, where's the faculty on this? And I mean, younger folks in the audience, do you expect to mature into a professional environment in which your output is going to be put only into walled gardens? You're not going to be sharing in a social, aren't you going to want to have some kind of social media tools to enhance your scholarly communication? And where is that? Isn't this an institution that's supposed to be breeding leaders? Where's the leadership here on this campus? I mean, we need a champion here. Stuart Schieber made it happen at Harvard. He was one of those guys taking his scholarship to the recycling center on Saturdays. He was rewriting copyright agreements himself until we came along and said, Stuart, here, I'm a lawyer. Try this. He said, fine, thank you. Started using the addendum. But he was doing the hard work of going back and forth one-on-one with publishers, because he knew, he's a computer scientist, and he knew what the future is. He knew about how important machine access to the open literature is for his work and his discipline. And so what's going on here? I mean, the problem is, you know, you're inside the privileged world garden and you say, I don't have an access problem. Right? Now, we did find one resource that's on the computer where you do have an access problem. There is one Nature publication that you, even at Columbia University, don't have access to. The other dirty secret in the academy, right, is I don't have an access problem because if I find an abstract on the web and my library doesn't have it, I'll send an email to the author and they'll send me their paper, right? Because they're my peer, and that's peer-to-peer file sharing. Right? There's a black market in PDFs that takes the pressure off the access problem if you're in the club. Right? But where's the leadership here? I mean, it's time. We've been doing this for too long. It's getting old. It's time to wake up to the possibility, because it's an opportunity story. I mean, the publishers are seeing it as a threat story. The more advanced publishers, including Elsevier, know that they're playing the end game on the walled garden strategy. They know what the future is an open code base of text on which you add value-added services where we can start linking the text to the data, to the models, right? That's the future of scholarly communication. And they've got their little research and development wing working on that. And meanwhile, scholarly societies are blind to this for the most part. And it's really time to have that conversation. It's getting, you know, we're wasting time here. We have all of these great digital tools that are not being deployed in the one area where they can have the most socially beneficial impact. So I guess I want to ask the audience, what's going on? Where's our champion? What do we need to do to move the conversation on this campus more? Because we got, you know, Jim helped recruit Kenny. Kenny's a great resource for this institution, and I understand he's been having a lot of conversations. But it really is time to step up to the plate, Columbia. I mean, I'm serious. Harvard's up there, MIT. How long do you want to wait? You want to let Cornell go next? Because there are conversations there. You know, who's the first New York institution to step up to the plate and have an institutional policy on open access?
And you can add University of Illinois, which we're hearing about, maybe on the brink of another similar kind of open access resolution. There's sort of a partial answer to your question. And we have been working with faculty diligently to raise awareness about this issue, meeting with faculty at their departments, engaging in very much these same kind of discussions. There's individual leadership within the different departments. One of the challenges of our cultural environment of Columbia is we have very little means for one department to talk to the other. We don't have a faculty senate. We don't have a forum for communication across the university. So we're tapping pockets of isolated support, but that isolated support is not finding a good way to communicate with the peers who are like-minded at other parts of the university. And so in a way, Patricia Renfro is here from the library too. She and I and others, and there are a few others in the room, who've been working the faculty to raise awareness. But this is the route that we need to go at Columbia. There isn't a faculty senate where we can introduce this subject and begin to engage people on these issues at that level. We just don't have it. We're an amalgamation of schools and departments, and that's making the movement in the direction that you described very difficult. We really don't even have, even Harvard was split into its different schools, but they started with a big mainstay school, a Faculty of Arts and Sciences. And while we have that kind of school, we don't have the Senate, the organized Senate with faculty authority functioning within all of the schools. And so even there's unevenness across the institution. So that's been part of the challenge. That's been a big part of the challenge.
One more question there?
It's not really a question, just sort of a comment. This is, I'm in physics, and maybe I just, prior to being in here, I didn't realize this was really a problem, because I don't think we really have that problem in physics and astronomy, because preprint servers have become sort of the default. Like, repository, I mean, you still need to have this stuff reviewed, right? And there's people who post all kinds of crap to the, we call it the archive.
Right.
But, that stuff kind of gets vetted out. Nobody really gets anything. I haven't downloaded a paper in 3 years from an actual APS journal. You get everything off the archive. So, I mean, I don't know how that happened. This sort of dynamic model was that.
Yeah, I mean, you guys are the poster child.
Well, physicists invented the web, right? So, but you're still using Web 1.0, even with archive, right? Because archive was preprints. The preprint server was the U.S. Post Office, right? Until so.
Or doors.
That's a technological issue, not a social one, right? And I'm wondering, whether.
I mean, that's a huge thing. I think the cultural differences in disciplines are enormous. My career started in astronomy, so I mean, I can remember going to places like NOAO and seeing yellow papers posted on the doors, right? The precursor to preprints that we then slapped onto Paul Ginsparg's computer and made archive out of. But that culture doesn't just translate neatly into biological sciences. Yeah.
Does it really not? I mean, I know you're saying we don't really have a lot of information.
Absolutely.
What's the big deal?
So for biologists, biologists are actually a little bit more forward-thinking. Biologists, chemistry, they would never share their stuff ahead of time. I mean, the idea of preprints, good Lord. Sociologists, I don't want anybody seeing my stuff before I milk my data set for all it's worth. There are loads of disciplinary differences that, I mean, it's really interesting, actually, to...
You want to maintain a little bit of control. Like, you're not publishing huge data sets on your own house. You're
Right.
not putting all your eggs out there, but you need it out, but it's still.
Yep.
I'm sorry. Physics is a totally different world from the other disciplines.
It is.
With you in physics too, though. I mean, there's this really interesting movement in high energy physics. Are you aware of the Scope 3 proposal to flip the entire discipline of high energy physics to an open access model? It's this proposal that CERN's got out on the table that they're asking us collectively to look for a way to fund the flipping of all the APS journals, the Institute of Physics, Springer, there's a couple of other, the major publishers, just in high energy physics. They want us to take the current investment that we're making to support subscriptions and essentially reinvest it into a payment that would keep those journals going, but under an open access model. And the request is coming from from CERN saying that physicists are using the preprint server so much that the journals are actually in danger of going the way of the dinosaur, and there's a concern that then what will we use in high energy physics for quality benchmarking, tenure, and promotion, that we need this imprimatur of this final journal quality. So physics is in a completely different position than just about any other discipline that I can think of.
Yeah.
Yeah, and I just want to add to that. I mean, the other odd thing about the physics situation is that those journals are still considered very important for credentialing and promotion and tenure. So they're being published at considerable expense and taking a big chunk of library budgets just for that sort of credentialing and long-term archiving role in the literature, which is sort of somewhat insane, given that you're all reading in the archive and getting all your access in there. You sort of wish that there could be a credentialing from the archive instead that would be a far more economic way of doing this.
If there was some way for the journal just to be relegated to the status of being a market maker for peer review, and that's it.
Yeah.
And put it on the paper and do anything.
Yeah.
Because Spires already track citation count
Yeah.
and they grab it off the archive and just add little stars. They also run the journal.
So for the really forward-thinking disciplines, and I was invited to address the executive committee of the American Physical Society, and I tried this out on them, right? That this is what member service ought to be, that peer review ought to be disaggregated from the dissemination, and that scholarly societies ought to be taking care of the peer review function for the discipline, and let the dissemination take place through archive or other formats. And so please take that idea and run with it. I think it would be great, and I think physics would clearly be the first discipline to be willing to contemplate a model like that. But it's, again, once you start thinking digitally, you can disaggregate so many things that were bundled in a analog world for analog reasons.
So we're basically almost already there, though, right? Because like, if this the editors of like physical review are all physicists, and then they handle that process, and then once they say, okay, accepted, now it kind of gets handed off to somebody else in like the publishing side, and nobody else. I mean, it seems like even within journals, those seem to largely worship each other. So, yeah.
But I would say ask two questions. One, are you a member of American Physical Society?
Yeah.
If any of you are members of scholarly societies, this is a hugely important role that you can play, to talk to your scholarly societies as the members, as the people they're supposed to be serving, about what your vision is for how they should be disseminating your material. It shouldn't just be, the conversation shouldn't just be limited to, this is how I want you to manage my copyright. I mean, there are these kinds of issues that they're supposed to be listening to you. But I think a lot of members of scholarly societies are not speaking up and saying, this is the direction I want to go in. APS lobbies extremely hard against things like the NIH policy, even though it doesn't directly affect them. There are people that we run into probably the most frequently in favor of things like that HR 801 and in opposition of the NIH policy. It is sort of shocking, but those are the positions that scholarly societies, your scholarly societies, are taking that are, I would think, in direct opposition with what maybe your desire for them to do would be. And they're not hearing from members otherwise, so they're continuing to act in that way. It's a hugely important role for individual society members to take.
Okay, I want to thank you all for coming. This may be the last one for this year, but there will be another series next year.